the Ninth Circuit Court of Appeals has come back and ruled that the lower court that granted a TRO stopping Trump's illegal ICE raids and unlawful detentions is valid. And that's a big victory. Today, we're going to analyze that as lawyers from the Los Angeles area that are kind of living in the middle of all of this happening. I'm Shant Karnikian. That's Brian Kabateck. We're two lawyers at a firm called Kabateck LLP. This is Civil Action on the Legal AF Network. Hit that subscribe button if you like this content. And Brian, let's dive into this opinion. Let's start with the background on it.
Yeah, let's start with just a very simple factor that people should understand, which is the Central District of California, the judicial district we're talking about, goes from San Luis Obispo, kind of in the center of the state, all the way down to Orange County, includes San Bernardino. It's not the entire state, but it's 20 million people. So it's huge. And 47% of those 20 million people identify as Latino or Hispanic. So it's a huge region, and that's extremely relevant because if you're stopping people solely on the basis that they're Latino or Hispanic, that means you're going to stop one out of almost every other person, right? Which is ridiculous.
Right.
I mean, people that live here in Los Angeles understand the impact that this Trump administration is having on the people of Los Angeles. And this ruling puts a stop to what they've been doing.
Right. The case was brought by some immigrants' rights groups and some actual individuals who were impacted by this. They sought a what's called temporary restraining order that immediately stops certain actions that are being challenged, which would ban stops of people based solely on race, ethnicity, language, location, or who they're with, without any sort of reasonable suspicion, without any articulable reasonable suspicion, real reason to stop them. And I think it's an important case because it really, we talked about this, we covered this before. A lot of other people on the network have covered this, but it seeks to protect the Fourth Amendment, certain rights that are enshrined in the Constitution and in the Fourth Amendment that say that you can't just stop someone. That would be lunacy. That wouldn't be a democracy. That wouldn't be a free country if you could just stop someone and arrest them and detain them, even if you're not going to charge them with something, just based on the color of their skin or the language they're speaking, how they're speaking, where they are hanging out. You need more than just that. You need reasonable suspicion. I think it's important also in Los Angeles, because as Brian said, so much of the population identify as Latino. And, not all of those people, that nearly all of them, not even a majority, a small minority of them are undocumented. So this would kind of, just open up the floodgates for everyone to stop. So I think it's an important decision. Now, what's the significance, Brian, of the Ninth Circuit Court of Appeal affirming the lower court's decision?
Well, first of all, it means that the decision is final until the temporary restraining order at least is final for the time being. The Supreme Court could take it up. They did limit themselves to the district, which is consistent with the Supreme Court decision earlier this year. And I don't want to go too far down that rabbit hole. What I want to talk about, though, Shad, is how this Trump administration is just full of liars and people who misrepresent the truth. And I don't know how you would feel as a lawyer having to defend this for the Trump administration. So one of the big issues here was, without a dispute, Stephen Miller, who is Trump's henchman, there's no other way to categorize him or call him anything else. His henchman came out on Fox News in May and said that they wanted to round up 3,000 illegal aliens a day. That was their goal. And that was sort of a cornerstone of this action that was taken. The plaintiffs in this case were taking, is they're saying the only way you're doing that is if you're stopping people on the street and asking them for their papers, and you can't do that. And the judges in this Ninth Circuit case said, is that true, basically? And the lawyers had to submit a letter saying that basically said, well, there's no rule about that. I mean, there's no rule, but yes, somebody in the administration did suggest 3,000 people a day, but there's no official rule. I mean, how does that sound to you, Shant?
Not even suggest. I think they stated it as a goal. So that's kind of crazy. That's like, someone saying, well, we didn't order the hitmen to kill that guy. We just said it would be ideal if he was killed, or we aspired to kill him. We didn't give the official order. So it's talking out of both sides of your mouth, right?
Well, it's like somebody in a company. I mean, do whatever example you want, but it's like somebody in a company saying, we're setting a goal of 3,000 widgets a day. And then later saying, well, you didn't make 3,000 widgets. Well, it was just a goal. No, it was the company president telling you to make 3,000 widgets a day.
Right. And I think in this instance, the quota that they came up with for either deportation or arrest or detainment of people was Stephen Miller, right? It was like an advisor to the president.
Henchman. I'd like to call him the henchman.
Yeah, I don't know if that's his official title, but it should be. Right, because he's the one that does all the dirty work and comes up with the immigration.
And guess where he came from, Shant? Guess where he was raised?
He came from Los Angeles. I mean, he came from, I think he went to Santa Monica High School. He came from Los Angeles. And I don't know, someone really got his goat, and he really has this thing out for immigrants. He hates immigrants. With no regard to whether they're here legally or not. I mean, there's all kinds of old videos of him saying nasty things about immigrants. It's kind of wild.
There's a couple other things here that are significant and worth pointing out. First of all, the plaintiffs, meaning the individuals and the organizations you were talking about, had 21 sworn declarations about what was happening. And in response to that, Shant, the United States of America, the government, the Trump administration, how did they rebut or respond to that evidence of 21 declarations of what was happening in Los Angeles?
What did they do? I'm sure they had a bunch of their own evidence and they disputed all of it, right?
Nope. They submitted 2 declarations. One was from an official at ICE who talked about their training. And the other was from someone from Customs and Border Control that talked about both consensual encounters and investigative detentions. Now, this is interesting. That's all the evidence they had. So they didn't even refute. They didn't respond to the evidence that the government, that the plaintiffs in the case submitted. What I wanted to point out, though, about this is the government is trying to say that they were doing a lawful job here of trying to round up people who were undocumented in this country illegally. And we know that, in some limited instances, they had identification of where people were located and they'd show up with warrants and they'd arrest them. But that's not what happened here, right?
No, this wasn't. I mean, this TRO specifically applies, and the Ninth Circuit, when they issued this, affirming it, specifically adopted it. They were using just factors like race or ethnicity, speaking Spanish or having an accent, presence in certain areas, and the type of work that they were doing.
Not even that. Let's just take the case of Jason Brian Gavidia. He's one of the plaintiffs in the case. He was born in the United States. His first 2 names are clearly not Latino. Jason Brian. My name's Brian. I'm not Latino, nor am I Irish. But he's a businessman who rents space in an auto repair yard, a tow yard. And he heard some commotion. He went outside. All of a sudden he saw agents wearing green vests and guns, and they slammed him up against a fence, and they demanded to know where he was born, what hospital he was born in. And he said, I don't know. I was born in East LA. I don't know. And they had demanded to see his identification. They gave him his real ID and his cell phone. They took his ID and his cell phone, and I don't think they've returned his ID to him. They still have kept his real ID.
These are just thugs trying to go out and rile people up and hoping that they catch something in there. It's sort of it is a little bit of theatrics or a PR stunt, but at the same time, you allow this to happen. Where do you draw the line?
It's so severe, right?
Yeah. Do you think this will go up to the Supreme Court?
I think eventually this will go to the Supreme Court. I think the reason this will go to the Supreme Court is because the Trump administration is determined to take it there. The Trump administration believes that they have a friendly ear at the Supreme Court. I don't know about this one, though. This is basic, fundamental, first-year law school criminal procedure law about you can't stop people without a reasonable suspicion on the street, and the color of their skin is not a reasonable suspicion, obviously.
Even combined, all of those factors, the color of their skin, the fact that they have an accent, where they work, it even says that you cannot even combine. You can't use them individually or a combined set of those as a basis for a stop. I mean, all of that would be violative of the Fourth Amendment. I mean,
this should anger anyone who respects the country we live in is not the country where you stop people on the street and ask to see their papers. And that's clearly what the Trump administration wants. They want to be able to randomly stop people and ask to see their papers.
The other part of this that the Ninth Circuit affirmed, and this comes from the lower court's ruling, is the TRO requiring access to lawyers. So they need to have, these people that are detained need to have 7 days a week, legal visitation rights, a confidential line to speak with lawyers. You can't have it otherwise. And what we know is that a lot of these folks were being held downtown in the federal building in downtown in a basement or a basement room called BAT. And then again, that violates other parts of the Constitution. So they need to have access to lawyers because that's another fundamental component of criminal procedure in this country. You're right. It does go back to first year criminal procedure. It does remind me of some of the rules we learned there.
Look, I'll give you my final thoughts on this, Sean. I think, first of all, that you're going to see more on this. That I think that this is clear evidence that the Trump administration is at war with California, primarily California, that Stephen Miller, frankly, has a stick up his ass about California. He must have had some horrible experiences. Maybe he was beat up as a kid at Santa Monica High School, but has some horrible experiences in Los Angeles and wants retribution against Los Angeles. But I think ultimately this is going to stick. And I think these rules are black letter law rules. And to change them would require a radical change of the constitutional interpretation in the United States. So that's my final thought. You, as usual, get the last word.
Yeah, a law professor once taught me that the way you see whether a law works or not, whether it's legal or violates some set of rules, is by taking it to its extreme. So if you look at how the Trump administration has operated in these raids and sweeps or whatever we're going to call them, if you agree with their argument that they were making to the court that they should be allowed to do this and this is proper, then you take that to its extreme. By that interpretation of the law, they get to stop anyone and everyone. They could walk in right now to where you're recording and they could stop you and they could detain you and they wouldn't be violating any of your rights. As long as they can articulate, well, he looked brown. Or we suspect he's here illegally. Why? Well, we just think we do. Somebody told us, or illegals oftentimes are located in this city, things like that. So you take this approach to its extreme, you end up with some very absurd and unconstitutional results. You end up with an entire population in the city that is subject to detention, to arrest with no justification. So I think the lower court got it right, and the Ninth Circuit here got it right. It's an interesting opinion. It's a great analysis of the lower court's opinion, and we'll see what happens when this gets to the Supreme Court. I think it would be very hard for the Trump administration to be able to justify this kind of stuff. Anyway, I'm Shant Karnikian. That's Brian Kabateck. This is Civil Action on the Legal AF Network. If you like this content, please subscribe. We appreciate your comments and your feedback. If you want to hear about anything in particular, let us know. See you next time.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.